with, I will follow this outline that's indicated here. First, a brief reference to the Geneva Act or the Hague System and its membership and how it works. And then followed by an introduction of the roles that your office shall play as the office of origin of an application and as the office of a designated contracting party. As you know, the Geneva Act is one of the treaties governing the Hague System for the international registration of industrial designs, and it has at present 64 members, including 62 states and 2 intergovernmental organizations. Here is the list of Geneva Act members as of June of this year. And as you may see, the intergovernmental organizations that are party to this treaty are the European Union and the African Intellectual Property Organization. And among the member states, there are at present 4 ASEAN countries, as Mr. Louis was recalling: Brunei Darussalam, Cambodia, Singapore, and Vietnam. And here is the current geographical coverage of the Geneva Act. 89 countries that are either direct members of the Geneva Act or at least members of one of the 2 intergovernmental organizations that are members of the Act. As you may recall, the Hague System, very much like the Madrid system, can only be used by someone who has an attachment to a contracting party. And in the case of the Hague System, this attachment can be an industrial or commercial establishment, nationality or domicile, or habitual residence, which is more flexible than just domicile in one contracting party. That's attachment with one contracting party is necessary in order to be able to use the system, for any person to use the system. But unlike Madrid, in the case of the Hague System, there is no need for the applicant to have a basic design in the country of origin. An applicant can file directly an application without having, before filing that international application, a basic design in his country of origin. And another difference, quite important difference, is that under Hague, in principle, it is possible for an applicant to designate its own country for protection, something that is not possible under Madrid, where you need to have protection in your country of origin directly from your national office. The advantage of using the Hague System, instead of following the traditional filing route country by country, is that the applicant needs to file only one single application instead of several different applications in different offices, in only one language instead of several languages. And it has to pay fees in one single currency instead of different currencies. And it will need a local representative only in limited cases. So it is eventually much less expensive and less cumbersome as well to follow the Hague International route instead of several different routes and procedures to get protection for designs in various countries. Now, in addition to the advantages of central filing, the holder of an international registration also enjoys the benefits of what is called central management. And this means that he can renew his international registration every 5 years through a single request sent to WIPO with effect in all the designated country contracting parties of interest to him. And similarly, he can request that certain changes to his registration be recorded in the international register, also with effect in all the designated contracting parties where he so wants. So this is why the Hague System is becoming so popular. We will now see the role that your office should play with respect to industrial designs, international applications that are originating in your country. That is the role of your office as the office of the applicant's contracting party. In principle, there are two functions that should be considered. First of all, and most importantly, providing advice to national applicants wishing to protect their designs abroad by using the Hague system. And secondly, possibly also acting as a transmittal office. That is an office that receives an international application from a local applicant and sends it to the International Bureau of WIPO for processing. But as we'll see, we will see this is an optional function. The advice to be given to national applicants concerns at least the following. First of all, providing advice on the advantages of using the Hague system, how to prepare an international application, how to deal with possible irregularities and with possible refusals in designated contracting parties, and finally, how to manage the international registration throughout the life of the registration as such. So you should be ready to inform your nationals about how to prepare the international application, that is, what is the mandatory content of the application, the optional content, and including the fact that with respect to certain contracting parties, there is some additional mandatory content, as we shall see. You will advise them also, for example, about the fact that an applicant under the Hague system can file up to 100 designs in a single application, but only if all those designs belong to the same class of the international classification for designs, the Locarno classification. It will be also important to provide advice to your nationals regarding the presentation of reproductions and how it will be convenient for them to consult the Hague Guide for users concerning how to present those reproductions. Regarding where to file the international application, this will depend on whether your country allows or not for applications to be filed through your office. If you do so allow, the applicant will have the option to file the application through your office or to do it directly at WIPO. And in fact, more than 95% of international applications today are filed directly at WIPO and not through a national office. If you decide to accept the filing of international applications through your office, what is called in the terminology of the Hague system indirect filing, well, you should be ready to receive those applications in one of the official languages, English, French, or Spanish, and in the appropriate form, the M1 form. And you will have to transmit that form to WIPO, preferably within 1 month, with an indication of the date when the application was received in your office. Your office may charge a transmittal fee and may also accept to collect other fees from the applicant and send them to WIPO, even though really very few offices do so. If the applicant decides to file his international application directly with WIPO, he will probably do it through electronic filing. And in fact, more than 99% of the applications received by WIPO today are received through electronic filing, the electronic filing interface that WIPO has on its website, which is very convenient and very user-friendly. So I will not get into further details now. Okay. Is there's some
yes.
yeah, okay,
yes. Yes.
So I was saying that I will not get into further details now into how the international procedure follows now, just to make it shorter. But as you know, WIPO will receive the international application, will examine it from the point of view of formalities. And if everything is okay, it will record it, the international registration in the international register. It will publish it in the International Designs Bulletin, and it will notify it to all the designated contracting parties. So what we are not going to see now is what would be the role of your office if your country is designated in an international registration. First of all, you will find out that your country has been designated by having a look at the International Designs Bulletin. This is a bulletin that is published by WIPO every Friday on the WIPO website. So you can even download that information from the bulletin, arrange to have it downloaded automatically. And what is important to recall is that when you see that you have been designated, your country has been designated in an international registration, you will know that immediately from the very beginning, that international registration shall have the same effect in your country as a national industrial design application having been regularly filed with your office. And later on, we shall see that if it has not been refused, or if it has been accepted, it will have the same effect as an industrial design registered in your office. You will have in principle 6 months to examine the international registration and possibly refuse protection. Now, if your country allows for a position by third parties, you may have up to 12 months to do so. But a refusal of protection can only be based on certain grounds, in principle, substantive grounds that are envisaged in your law and that would apply to industrial designs that have been filed directly with your office. It may also be based on an opposition by a third party if your law so allows. No? If there are substantive grounds for refusal or an opposition, your office shall notify this refusal to WIPO within this prescribed period of 6 months or 12 months and provide all the information required for that purpose, and preferably in a form, a special form, that model form that WIPO makes available for that purpose. In this respect, communication with WIPO shall be either in English or in French or in Spanish, you may choose. And if the notification that you send, the refusal notification that you sent is irregular, WIPO will ask you to provide whether missing information is necessary. Now, if you refuse protection, the holder of the international registration will get that information from WIPO. He may then come to you and request you to review or to reconsider your decision, or he may appeal against that decision. It depends on what your law provides for in this respect. And what is clear is that he should enjoy the same rights and the same remedies as any applicant having filed an application for protection of a design directly with your office. Of course, if he has no address in your country, you may ask the applicant or the holder of the international registration to appoint a representative. And your office will eventually decide whether to confirm the refusal or to withdraw it. And if it decides to withdraw the refusal and to grant protection to the industrial design and in whole or in part, at least for some of the designs that are contained in the international registration, your office will then notify WIPO accordingly. Your office may also issue what is called a statement of grant of protection instead of a withdrawal of refusal. A statement of grant of protection, in fact, may be sent following a refusal or even in the absence of a refusal. And there are model forms as well to be filled in to notify such statements of grant of protection to WIPO. If WIPO receives from you a statement of grant of protection or a withdrawal of refusal, it will then record the international this statement of grant of protection or withdrawal of refusal in the international register, and it will inform the public through the bulletin. And the international registration will then be protected in your country. The international registration that has not been refused shall enjoy in your country an initial period of protection of 5 years. But this may be renewed every 5 years and up to at least 15 years. If the law in your country happens to offer a longer term of protection for industrial designs registered at your office, for example, 25 years, then the international registration will also enjoy in your country a maximum duration of protection of 25 years. During the life of the international registration, all renewals and changes to the international registration will be recorded directly by WIPO and will have the same effect as if recorded in your office. In this respect, there is not much work for your office to do, except maybe regarding a change in ownership, a correction, or an invalidation. In the case of a change in ownership, whoever asks for such a change, may be the owner himself, or it may be the transferee in some cases, will file the relevant request directly with WIPO. WIPO will record the change in the international register to make it public against third parties. However, the validity of that change in each designated contracting party will depend on the law of each of them. For example, if your country requires some statement to be presented or some document to be presented for the change of ownership to be valid in your country, well, you may ask for such document to be submitted to your office, certifying the assignment, that the assignment has effectively been made. Now, concerning errors, if there is an error regarding an international registration, WIPO will make the necessary correction and will notify it to your office. Now, the effects of the correction will depend very much on the type of error. If it's a minor error, maybe there's no need to go through it again in much detail. But if it is an error that would mean that the international registration no longer qualifies for protection in your country, the international registration will go throughout the same procedure as if it had been that change or that correction in the international registration will go through the same procedure of a substantive examination and possibly refusal on the basis of substantive grounds, as if it were a new international registration. Would be the procedure to be applied. Finally, regarding invalidation, an international registration will be subject to the same provisions and the same procedures for invalidation or revocation or cancellation as may be envisaged in your law with respect to a national registration. Simply that the holder of the international registration should in any case be afforded the opportunity to defend its rights in good time. If the invalidation procedure concludes with the invalidation of the right and there is no longer possibility to appeal that decision, then your office shall notify all those details to WIPO, and WIPO will take note of the invalidation in the international register and will publish a notice in the international bulletin whereby that international registration is no longer valid in your country. Well, with this, I conclude this first presentation.